No, job matter is not. So, Lord, when the incident happened, he was detained for a little while, but on the, I believe, the instruction of the Chief Justice of India, he was allowed to go. Probably we also thought the matter has got a quietus. We also didn't initially decide to come with this. But his conduct thereafter, going to the media, saying, I'll do it again. God has asked me to do it. I mean, all kind of this, Lord, this is something which is completely, and the way this whole thing is being glorified, with great respect, Lord, ultimately your Lordships, Lord, have sufficient powers to ensure that this glorification doesn't happen.
Mr. Udasim, the point is that there is absolutely no doubt that the very first act is a serious and grave criminal contempt. There can't be any doubt about it. The manner in which he acted, nobody can pardon.
Nobody can pardon.
In the ordinary sense. The subsequent conduct which you people have pointed out, that of course again aggravate the situation. The only thing is that once the Chief Justice of India, Honorable Chief Justice himself has pardoned, and
that is in his individual capacity, Lord. We are for the institution. Even as an individual, Lord, if he decides to not go ahead with the matter, we as being, Lord, integral part of this institution, and your Lordship being on this, the other side, we being on this side, we can't let this incident go, Lord, for the simple reason that it's the institution. Today, Lord, jokes are being made. People are making jokes of this, Lord, and the jokes are being circulated. I am only saying, Lord, this can't be allowed to go on. This will ultimately bring a lot of disrepute to the institution.
You see,
disrespect to the institution.
We are with you absolutely, particularly on the issue of that where you are seeking some direction with regard to
John Doe, etc.
security guidelines and all these things. We are inclined to examine that part of the. But as far as the contempt individual is concerned, we don't want to comment. But as you say that he is making this kind of statement, what is his stakes except to get a media highlight that today you do something and he will again try to say something. So better it is to.
Lord, the courts are not powerless, Lord, even to see to it that
such
this kind of
matter should be thrown with the same contempt as somebody commits.
I appreciate, Lord. Let me do this, Lord. Today your Lordships can only issue notice. Let him come and at least express remorse. Your Lordships can take a call at that stage. But if he doesn't express remorse, then send him to jail from here only.
Why to?
It is not be fair, Lord, for your Lordships to pardon.
Why to give?
Institutionally, Lord.
Why to given such an importance to such a person that issuing notice and calling him?
It is not our giving importance, Lord. He is getting the importance by virtue of this incident. It's not our importance, Lord.
I think last time also probably.
I know, Lord, your Lord. I also thought about it, Lord. We also thought about it in the executive committee. We felt that whether we should, Lord, do this, but ultimately, Lord, it has become a joke in the society.
Let us bar and bench both. We should consider on broader issues and the larger issues that the guidelines which you have probably thought of it. That's a very well thought of idea by the bar, and we appreciate that initiative. We can think of in those terms that what should be there, and
your Lordship may issue notice simpliciter for the timing. I don't want, Lord, your Lordship to confine.
The thing is this, as you are rightly saying, and it's a question of the institution itself.
That's all we are concerned.
And when it's a question of institution, not only judiciary, it's your sentiments as officers of the court.
Lord, we are also being ridiculed, Lord, in society.
To take into consideration. And these are also a part of the scheme of the Contempt of Courts Act. And that is why the Contempt of Courts Act makes a very significant departure when it is a contempt on the face of the court.
That's right.
The throwing of a shoe, shouting slogans in the courtroom are contempts on the face of the court, which are contemptuous under Section 14 of the Contempt of Courts Act. In such cases, it's left to the judge concerned as to whether the judge will feel it prudent to initiate a contempt proceeding,
no, Lord,
or
on the contrary,
give it a pass. With 1 second, Mr. And in this case, the Honorable the Chief Justice, in his glorious magnanimity, chose to ignore it.
For the IPC, Lord, that will only be for the IPC.
No,
For booking him, Lord, as a
Mr. Singh,
criminal offense.
let me indicate to you what is going through our mind. And in this situation, when the judge in whose face the contempt is committed chooses to ignore, is it within the domain of another bench or even the Attorney General to give consent under Section 15? Please see the words of Section 15.
Lord,
Contempt other than a contempt under Section 14. And
Lord,
this,
can I-
in our understanding, the throwing of the shoe, the shouting inside the court hall are contempts on the face of the court. And for that, when the judge chooses not to initiate contempt, it does not fall within the domain of the procedure under 15 to pray for issuance of a contempt rule by way of a consent from the Attorney
can I,
General.
Lord, respond, Lord?
We are conscious of the second limb of your argument, that there has been an effort of glorification. And that is where, as my brother indicated, we would ensure the pendency of this proceeding so that necessary guidelines can be issued with regard to publications in such cases, as well as ensuring security. That would be a more proactive exercise in
No, then of course your lordship will-
purity and
will
that's
defend,
what
sir.
we are very
Can
much
I- can I-
rather than an antagonistic
Lord, can I-
process.
can I
of
respond to
bullying,
what-
calling someone for
Lord, can I respond to what my Lord?
Yes, sir.
Lord, as far as the learned Honorable Chief Justice deciding not to take action is his personal
No,
view.
sir.
It's
No,
not an
sir.
institutional
There-
view.
there we
It is not
are-
a
we
view
are
which can
joining
be said
to-
to be taken on
Mr.
behalf. Lord, I can
Singh.
understand if he had taken the matter or discussed with your lordship. This is
Yeah,
not something which is an institutional view taken by him.
His lordship then and there decided.
No, but that's his
Ignore it.
personal view,
That's the end.
not
No,
for the
sir.
institution.
Excuse me,
That is an
sir.
end. That is an end to the contempt proceeding on the face of the court.
Excuse
Now
me, sir.
come the subsequent publications. And for that subsequent publications being intrinsically connected with the contempt on the face of the court, whether would it be prudent to break up that issue? And that is why on the
And,
last
and
occasion
what
we
the
said,
Chief Justice
let there be a natural death through this.
So let me then one more plot, sir. That Honorable Chief Justice condoned that one act of his. But what he's doing thereafter of glorifying this act and saying, I'll do it again and again, that the Chief Justice was not aware, Lord. He could not have been aware. What we have done, Lord, is on the basis of his subsequent conduct. This could not have, Lord, been this could not have come to the Honorable Chief Justice's mind when he decided to just leave this as a one-off incident.
Mr. Singh,
But what
how
is
many
happening
people-
thereafter?
How many posts are put on the social media?
Oh, my God,
How
it's
many
everywhere.
notices are
Everywhere,
going
Lord,
to-
everywhere.
This is
He's saying,
exactly
I'll go to
what we are
Mauritius.
saying.
He's saying, I'll go to everywhere. I'll do it again. And he's saying as if the Lord is asking him to do it. Just see,
we
Lord,
are
it's not
saying,
only
apart
the
from
institution. It is also, Lord, it's an insult to the God whom he's, Lord, wanting to, Lord, sort of glorify.
Mr. Vikas Singh, that issue of glorifying is a serious concern. We definitely will take that, and of course, with all of your active support and opinion and suggestion, and Learned Solicitor is also here, we will definitely would like to lay down some guidelines. But today, giving undue importance to one individual
So it's not a question of,
is
Lord,
unnecessarily, this will rather lead to his glorifying more.
no, Lord, no, with
Person
great
will-
respect, no.
What is his stake in system?
What the Chief Justice, Lord, condoned was the
Such
physical
kind of
act.
person.
But
take
what
a-
he has done thereafter, Lord, is actually the insult to the
Mr.
institution.
Vikas Singh, take us from us. Such kind of persons have no stake in the system.
I know that, I know. Lord. That-
They don't have any
The
stake
very
in the
fact that
system
they've
at
got a
all.
black coat, Lord, is used by them to, and that is why the Bar Council has already taken action. We have also
And
not
giving
terminated
any-
his membership. He
giving
was a
any-
temporary member with us.
giving
We are also
any-
becoming careful in giving membership now, Lord.
That's
We
why
don't
we are saying, giving any undue importance to a person who does
no,
not
Lord,
deserve
no,
it
it's not,
at all.
Lord,
We will be rather, we will kind of look at the large hearted and magnanimity with the Honorable CJI has shown. We will be, we.
That
must
was
respect his
the
lordship's
incident, not
sentiments.
what he's doing glorifying thereafter. The CGI didn't know that he will be glorifying this incident.
But-
CGI also probably, Lord, with great respect, he must have thought that if I send him to jail today itself, probably it may
His
send a
lordship
bad.
will do it.
So the fact that he let him go is the reason why, my lord, he felt that he's emboldened to say that I'll do it again and again. Actually, my lord, if you just see how the whole thing shaped up, if he had been actually taken to jail that very day, probably this glorification wouldn't have stopped. The fact that the Honorable CJI in his individual capacity felt that let it go and let him be let off, actually has resulted in this happening, and which is the subsequent conduct because of which we came. We would not have come otherwise, my lord. Probably we would have also given it a quietus of not giving this person any importance.
Any instant reaction resulting into a punitive measure would have again flared up so many irresponsible people who are there. You know very well better than us, because we may not get time, you may also not get time, but the other young people in the bar, they know it very well that what kind of the social media trails and all the trolling starts.
So, my lord, all that can be not controlled by the judiciary.
Yes, yes.
We have seen instances
that-
where your
That's
lordship
why
has.
that's why we want to request you that let us concentrate on that part. We are not closing the matter. We don't want to close. In fact, that issue, we would request Mr. Solicitor also,
But
because that what is their response, what can be the, what kind of, preventive or safety measures.
Preventive and, my lord, this kind of subsequent
Regulatory
conduct.
measure, my lord, for this kind of trolling, my lord, because I, of course, my lord, stand with the bar. I support them. But as, my lord, so far as the criminal contempt is concerned, ultimately, as my lords have said, my lord, it is the honorable judge concerned. But if petition comes, it is your lordship's wise discretion which would ultimately prevail. Another angle to, my lord, what we are projecting as a bar can be that his shelf life in the social media would be for few more days. He's not a prominent figure, my lord, that he can survive on the social media for long. Possibly issuance of notice might extend that shelf life.
Exactly. It will-
He might start playing victim. He might start playing a hero of a victim of a system, etc.
Let us understand the modus also, that it all becomes a commercial venture, a saleable item. Today, because after all, how long they will be able to commercialize it? It is bound to die its own natural death. The moment we take up some.
Lord, there are disgruntled elements in the country who
Yes.
will continue to use it even if your lordships don't take any action. I can tell your lordship this. He is now going ahead and saying that this judge is doing bulldozer. Just imagine. He is using just see page 35 of the petition. How, what business, Lord, is that the remit of what he was ultimately doing, Lord? The showing of the truth. I mean, ultimately, all this, why we came, Lord? We came only because what is happening subsequently is actually showing this institution in, Lord, very, very, very poor
This is
light.
pure commercial game and gain. So long as this so-called channels and all these things, they know that yes, by projecting him for any other XYZ thing, for any negativity creating, and it fetches revenue for them, they will continue. The day it becomes obsolete, they will stop it.
Lord,
That is what.
unfortunately,
He's
in our
the
country,
product, my lord. Right
It's a
now, he's
necessity.
able to sell himself.
Say,
tomorrow he may then start saying that Supreme Court didn't have the guts to issue notice. I mean, I don't understand what he will do after this, but
He
I'm
has
only saying
already stated, my public,
your lordship should actually
Tripal,
have him at least come here and at least respond to
enter
what
this
this
kind of issues. These are very sensitive issues. Don't file. We don't appreciate filing of writ petitions for this purpose and all this.
And my lordship, nobody could have been more aggrieved than me, because I represented the petitioner in that matter.
in that particular proceeding. I
the
checked
entire
the proceeding.
proceeding. And in fact, nothing of that sort happened where, okay, that was never the intention of the Chief Justice. And
That
in
is-
fact, I did clarify also, if at all somebody is aggrieved, it is me who had to be aggrieved.
His
As a
client-
petitioner,
his
my
client-
client.
More for that,
Mr.
Lord,
Noli,
if-
we can assure you, we are very thick-skinned persons.
No, Lord, thick skin
Not
does not help in such matters, Lord. With
This
great
is what-
respect, Lord, thick skin
This is
will
what
not
our
help.
orientation is there for. By the time we come here, we spend sometime 1.5 decades. Sometime by now, I have spent more than 2 decades. Honorable CJ had spent more than me. You know, each one of my brother has spent, look at, more than 15, 16 years. Each one of them has spent so many years.
Lord,
Chief
fortunately,
Justice already completely misspoke. The Chief Justice has been
I am elder to all of you, Lord, in the Supreme Court.
Well, even otherwise, the Chief Justice has been completely misquoted as regards the
we
actual
also
proceedings
felt
that are
the
there.
same what your lordships are putting to us. We also felt when we deliberated in the executive committee, we felt the same way that are we not going in, but then we realized that if we don't do it now, this is becoming, this institution is being taken as a joke, Lord, and it is becoming a social media.
Today, there is no question of closing anything. We would like to have your assistance and of course from all sides. Just ask your 2, 3 juniors to collate all the trends, how they and what kind of things are moving. Second, please suggest the measures for the preventive measures.
We'll do that.
And we'll request the same thing to solicitor also.
We
Yes,
shall assist you.
we'll discuss.
We take up after 1 week, 10 days, whenever you want, and
Very good.
then consider that.
Your lordships also retrospect whether your lordship will go the full hog or only limited to the
Yes.
that part. So have it after a week, not the weekend.
No, don't file a repetition, please. I mean, what is the difference between that gentleman and you? If you also are doing for media publicity, please leave it there. Be bold enough, and you see, the other side of the just, it's all right.
No, he's a member of the bar. Bar is here. Mr.
Bar-
Vikas
when
Singh
the
speaks
Supreme
for all
Court
of
bar
us.
has come, the banyan tree is here where the need of all of you
In
unnecessarily
fact, the
filing.
learned attorney general didn't give consent to
These
any
are those asked for
5 people
repetition,
individuals that he said,
Yeah.
"Oh, I was waiting for the bar to do it, and that's why
Both the repetition are dispute being not maintainable.
deeply obliged. ma'am.
From a more so when all the issues have been comprehensively raised by the Supreme Court Bar Association. Post this matter for further consideration on so and so date.
Deeply obliged.
Thank you, most respected sir. My prayer is suggestible
No, it's all right, Dr. Pa.
and thank you, sir. Please consider main prayer 1. That's quite different, which you
You give
are,
your suggestion to Supreme Court Bar, they will place on record.
thank you.
Now that we will be, whatever assistance we need, the Supreme Court Bar is providing.